In Bank of Bihar versus Damodar Prasad, the plaintiff bank lent money to Damodar Prasad on the guarantee of Nath Sinha. In spite of demands by the bank, the loan was neither repaid by Damodar Prasad, principal debtor, nor by Parasnath Sinha, the surety. The bank then filed a suit against both the principal debtor and the surety. A decree was passed in favor of the bank, but with the condition that the plaintiff bank shall be at liberty to enforce its dues against the surety only after having exhausted its remedies against the principal debtor. In its appeal before the Supreme Court, the plaintiff challenged the validity of the condition in the decree that the bank should enforce a decree against the surety only after having exhausted the remedies against the principal debtor. The Supreme Court held that the very object of the guarantee is defeated if the creditor is asked to postpone his remedies against the surety. The trial court gave no reason for this extraordinary direction. It said that the principal was solvent against the principal. The solvency of the principal is not a sufficient ground for restraining execution of the decree against the surety. It is a duty of surety to pay the decree-late amount. On such payment, he will be subrogated to the rights of the creditor, stating that the surety has no right to restrain execution against him until the creditor has exhausted his remedies. Against the principal, the court ruled that before payment, the surety has no right to dictate terms to the creditor and ask him to pursue his remedy against the principal in the first instance. In the absence of some special equity, the surety has no right to restrain an action against him by the creditor on the ground that the principal is solvent or that the creditor may have relief against the principal in some other proceedings. Where in a guarantee deed, the liability of the guarantor was coextensive with that of principal debtor. No clause in guarantee deed which provided contrary to contract. Liability of a guarantor was not discharged. Suit filed by the appellant was decreed against the defendant. Appellant bank was at liberty to recover loan amount jointly and severally from all the defendants.